Good day, everyone, and welcome to another session on school legislation and finance. Today, we will talk about Bill of Rights vis-a-vis the students' rights. This discussion um, was digested from the book authored by attorney Sarmiento, um, entitled "The Students' Rights and Wrongs." So let's begin. So the Bill of Rights, as defined by the Black's Law Dictionary, is a formal and emphatic legislative assertion and declaration of popular rights and liberties, usually promulgated upon a change in government. The Philippine Legal Dictionary, uh, corollary, defines it as the fundamental rights of person and property from infringement by any form of governmental authority, whether executive, legislative, or judicial. So, in simple parlance, the Bill of Rights is an enumeration of specific rights granted to any person in order to protect the same from any unnecessary encroachment or abuse by the government or its agents. So it is designed to safeguard any natural or juridical person, from the abuses which the state may commit in the exercise of its sovereign or inherent powers. Okay. So according to Professor Natura, um, in the outline reviewer in political law, okay, there are two general classifications of rights. Okay. And these are, number one, civil rights, okay, which are rights that belong to every citizen of the state or country and are not connected with the organization or administration of government. They include the rights to property, marriage, equal protection of the laws, freedom to contract, and more. So they are rights appertaining to a person by virtue of his citizenship and capable of being enforced or redressed in a civil action. Second is the political rights, which refer to rights to participate directly or indirectly in the establishment or administration of government. They include the right to suffrage, or referred to as right to vote, right, yeah, right of suffrage or right to vote, right to public office, and right to petition. So there are five theories on the recognition of student rights. Before there be any discussion on student rights, it is necessary that there uh, ought to be a discussion on basic theories justifying the recognition of the same. Okay? So in a Philippine Law Journal publication, in an article entitled Emerging Student Rights and Schools Disciplinary Authority by Reyes, okay, theories are comprehensively outlined as follows. Okay, so we have contractual theory, we have privilege theory, right theory, fiduciary theory, we have state agency theory. Okay, so let's start with contractual theory. So the most common view is that law on contracts prevails once a student is admitted in a university or school. According to the case of Anthony versus Syracuse University, it states that when a student becomes duly matriculated, meaning charge of tuition fee and other fees, okay, in a college, a contractual relationship arises or exists. A student having paid his tuition agrees to abide by the rules and regulations of the educational institution, accept a course, the course of study provided and must meet the tests as to attendance, diligence of study, and personal conduct. On the other hand, the school agrees that it shall provide quality education, okay, and that in the event the student successfully finishes the course and abides by the rules and regulations thereon, he will receive the evidence, okay, or what we refer to as certificate or diploma. Okay, so that is uh, the meaning of contractual theory. Okay, so a contractual relationship arises when the student becomes duly matriculated by an educational institution. Then we have privilege theory. So this is widely held impression that the admission of a student in a university is a matter of grace or of privilege, not as a right. Hence, once it's extended, it can be recalled or revoked upon simple grounds of what appears to be the best for the educational institution, or other grounds such as unbecoming conduct or failure to conform to customs. So this particular theory was held to be the justifying basis for certain educational institutions to expel those students who are simply not to the liking of the administrators. So it should be noted that the courts, okay, averred that even if attendance to a school, okay, is a mere privilege, okay, the school, okay, could not revoke it arbitrarily. Okay, so there is legitimate cause to withdraw the privilege only upon a showing that it is necessary to safeguard the ideals of a scholarship and or moral atmosphere. Next, we have right theory. So this is based on a socially accepted notion of the importance of education in every society. Okay, so it holds that that each child has a natural right to be educated for social and economic adequacy according to the needs of the times. So education is considered the most important function of the state and the local governments. So ergo, it is a mandatory requirement for the government to provide for free and mandatory education programs to its citizens. So this is done not only as an answer to the basic need of the citizenry, but also as a means to comply with the literacy requirement that would enable states to be globally competitive. Another one, we have the fiduciary theory. Okay, so many would think that the relationship between a student and his school is fiduciary one. Okay, so the university or the educational institution has an obligation to the students as a whole, to dismiss or punish those students whose conduct interferes with the education of others, and would also require that the accused students would be provided the maximum possible procedural safeguards. Okay, so it would place upon the educational institution, for example, the university or the college, the burden of showing that appropriate safety nets, okay, were provided, and that the university performed its obligations as a fiduciary. Finally, we have the state agency theory. Okay, so the state agency theory claims its inception from the concept that education is a function of the state. Okay, so all educational institutions are considered to be agents of the state, okay, in the implementation of its ideals and policies. So reasonable rules and regulations have their place, and the educational institution is justified, okay, to remove a troublemaker from its community. But okay, as when any part of the government deals with the citizens, the state cannot abridge, okay, or affect the substantial rights of an individual without due process of law. So these are the five, okay, theories on the recognition of student rights. We have the contractual theory, the privilege theory, we have the right theory, fiduciary theory, and the state agency theory. So we now, on the basis of these theories, discuss student rights. Okay, so as persons and citizens of the Republic of the Philippines, students enjoy the protection and guarantee afforded by the 1987 Constitution to all persons, okay, under the Bill of Rights, and these rights are carried by the student even upon entering the school campus or premises. So, as declared, by our Supreme Court, okay, in the case of Villar and others versus Technological Institute of the Philippines et al., okay, which was actually um, lifted from 135 Iskra 706. Okay. Um, it was held that the students enjoy, like the rest of the citizens, the freedom. Okay. They do not, to borrow from the opinion of Justice Fortas in Tinker versus Te Muan's Community School District, shed their constitutional rights at the school gate. So the parallels of constitutional liberties, which should exist for students on campus, okay, are not easy for school administrators to accept, since the view is still strong, even in public institutions, that educational institutions are essentially proprietary enterprises, okay, whose owners and managers have the rights, okay, to determine what to do with their property and whose good name is bound with the use to which it may be put. Okay? So, as stated by Reverend Bernas, okay, in his comments, okay, on the proposed bill on Magna Carta for the students, okay, so what is usually said, that a student does not leave his constitutional rights at the gate of the school. He takes them with him into the school. Okay, so this is true, but constitutional rights outside the school and constitutional rights in the school are merely analogous, not univocal. So the rights outside the school are those enjoyed by everyone within a society that is open to and intended for everyone. So because of the broad goals of the state, okay, and the great variety of the people in a state, the rights within a state are necessarily broad. Okay. Additionally, there are many things which can damage or destroy a smaller society, which cannot harm the state. A school or educational institution, however, is a specialized society with narrowly drawn goals. Only those who agree with the goals of the school are expected to enroll. The goals of the school and the interests of those who enroll in the school because of their belief in the goals of the school can be damaged by actions which would normally be tolerated in the larger society. So the rights of those who enroll in a school are those which will not conflict with the constitutional rights in the larger society. So the state society has rights, so do schools. So Philippine jurisprudence recognizes what are called the four pillars of academic freedom. Okay, so these are, okay, number one, yeah, the right to decide, okay, um, who may enroll, number one. Number two, who may teach, okay. Number three, who will be taught. And number four, how teaching is to be carried on. So this has a special significance for schools that have been established for very definite goals, such as religious goals. Let's take the case of a well-celebrated uh, litigation case of Nunn and others versus Dames, and it was held, that students should not be denied their constitutional and statutory right to education. And there is such denial when students are expelled or barred from enrollment for the exercise of their right to free speech and peaceable assembly, okay, and or subjected to disciplinary action without abiding with the requirements of due process. Also, it is understandable for student leaders to let loose extremely critical and at times vitriolic language against school authorities during a student rally. Okay. So, but the right of students is no license, okay, and not without limit. So, this would call to mind the famous adage, okay, uh, yes, we are free, but we are in chain, okay, which would highlight on uh, the responsibility that comes along with certain privileges or rights. So the conclusion is that despite the limitations that are recognized by law and jurisprudence as specifically to be exercised by the educational institution, say a university or a school or a college, a student does not, no, shed his constitutionally protected right at the school gate. However, okay, it is unquestionable that the rights of a student outside of the institution are clearly different from the rights inside the campus. Therefore, there is a need to distinguish. Okay. So the rights outside the school rather are those enjoyed by everyone within a society. Due to the broad goals of the state and the great variety of people in a state, the rights within a state are necessarily broad. In addition, there are many things which can damage or destroy a smaller society, which cannot harm the state. On the other hand, a school is a specialized society with narrowly drawn goals, and only those who agree with the goals of the school are expected to enroll. And this was pointed out earlier. Hence, the goals of the school can be damaged by actions which would normally be tolerated in a larger society. A concrete example is that of cross-dressing, okay? Which is why this is one of the more controversial uh, uh, issues or concerns, okay, in the purview of uh, the movements that promote, okay, the rights of the LGBTQ plus plus plus. Okay, so a concrete example is that of cross-dressing or the act of a male, okay, usually homosexual, dressing up as a female. Okay, so while outside the campus, such act is tolerated, okay, and accepted by a great number. The same act would be considered a taboo, okay, inside the campus, but it has to be stipulated. Okay, it has to be uh, supported by policies and are properly discussed, explained, oriented, to all the stakeholders, particularly the students. Okay, um, particularly if the institution is sectarian, okay, or run by a religious congregations that do not tolerate such. Okay, so it need to be stressed, okay, by citing American jurisprudence that the application of these constitutional rights to students in private educational institutions, be it a college or a university, is justified by three basic theories. Okay? And these are number one, attempts to treat the action in question of the private school as state action under the Constitution. That's number one. Number two, contract theories under which the school has, through written or unwritten agreements, bound itself to recognize certain rights of the student. And finally, common law rights. Okay, common law rights theories concerning private associations. Okay, so in explaining these theories, okay, so a respected American student rights advocate had this to say. Okay, so we have number one, the state action theory. So where under this theory, an attempt is made to show that the contested action of the private school is in some way state action, thus requiring the protection of the Constitution. So that is relative to the state action theory. In the same way, okay, in the state involvement theory, okay, so under this branch of the state action theory, there must be demonstrated a connection, okay, between the challenge action and the government involvement in the school. So the mere fact of state regulation or state aid to the school is generally not enough. Okay, so the showing can be made in one or of two ways. Okay, so under the first, it must be shown that the government regulation, aid, or other involvement is sufficiently connected to or shares direct responsibility for the particular challenge activity. Okay, under the second alternative method, okay, government involvement, okay, in the particular activity of the school need not be shown if it can be demonstrated that there is such a close and substantial relationship with the state in general, that the actions of the school and the actions of the state are substantially intertwined. Okay, substantially intertwined enough, okay, to regard the school as a whole as acting for or under the control of the states. So courts sometimes, okay, employ a balancing test, okay, weighing the harm of the government support for offensive activities against the harm of applying uniform standards to essentially private activity. So the balancing thus involves an assessment of the actual degree of the government support of the question activity, the extent to which the school is really private, okay, and the importance of the right being asserted. Then we have the public function theory. So a related attempt, okay, to treat the acts of private school as state action is found in the argument that the school performs the public function of education. Remember this, okay? So this argument must confront the counter argument that viewing private schools in this way will undermine the value of maintaining a private sector in education. So for some courts, okay, it must be shown that the school is acting as surrogate for the state. Okay? So the strength of this argument, okay, will also vary depending upon the particular state's pronouncements in its constitution and statutes regarding education. So the argument may be more persuasive in regard to elementary and secondary education, which is compulsory. Okay, so that would be for the public function theory. And finally, we have the last two. We have the contract theory and the common law rights theory. So let me dwell first on the contract theory. So it is widely accepted that the relationship between the student and the private school is contractual in nature. Remember what we have discussed earlier. Okay. And that the school cannot take action, okay, which breaches the student's contractual rights. The contractual terms involved may be explicit, okay, such as statements in published catalogs, regulations, okay, manuals, okay, and the like, in effect at the time the student enters. Okay, so they may also be implicit, okay, as when it is argued that so long as the student meets his or her contractual obligations, the school has a contractual obligation not to exclude him or her. So the school may, however, okay, be able to point to a broad reservation clause, okay, in which the student or parent has signed an agreement that the school reserves the right to exclude the student at any time for any reason. Okay? So doctrines of contract law would seem to allow students, okay, to argue that such reservation clauses, okay, should not be enforced because they are unconscionable or unreasonable, thus contrary to public policy, or that they are result of adhesion contracts, okay, in which the bargaining power of the school and the student are too unequal. This issue, however, okay, may not, this issue, however, okay, has not been widely addressed. So that's for the contract theory. Now comes the common law rights theory. Okay. So under the English common law traditions applied in part by American courts, members of private associations have certain rights to natural justice. Okay. So including protection against arbitrary expulsion and the right to notice and hearing concerning expulsion. So these rights, okay, have developed in part to protect the individual's valuable personal relationship to the association and the status which the relationship confers. This theory is sometimes related to tort actions. Furthermore, the rights of those who enroll, okay, in a school are those which will not conflict with the constitutional rights in the larger society. Ergo, while the society, the state society, okay, including the students, has rights, so do schools. It is therefore imperative to discuss these rights, which is why it is a fundamental, okay, requisite, no, for the study of education law, okay, or school legislation, the deepening of understanding of the inherent rights, okay, of the students as stipulated in the basic Bible, okay, of the citizens themselves, which we call the Constitution. So it is particularly outlined in the Bill of Rights and has to be upheld at all times. So now we proceed to the next discussion, okay. But before we do that, okay, allow me to end it here and to discuss further on the rights of educational institutions. Okay, as I have highlighted earlier, who may enroll, who may teach, how it shall be taught, and how teaching is to be carried out in the next session. So meantime, that will be all for our discussion on the Bill of Rights vis-a-vis the students' rights. Thank you.